Hello again. We'd like to finish up our Unit K on the judicial branch by now taking a look at Chapter 19. So again, make sure that you've read those pages in your textbook carefully in preparation for any quizzes and for the final test. We're going to be taking a careful look as Christians at our civil liberties that are granted by the Constitution and protected by the Supreme Court. The Supreme Court exists to protect ourselves from our own government and to ensure that we have certain rights are upheld, such as particularly of interest to us as Christians is the right of freedom of religion, free exercise of religion, and also that we are free from anyone imposing a state religion on us, freedom from church and state, as well as the ability to worship freely in a manner which we deem biblical. Amongst other rights, these are the most important, but also rights of speech. And we see some of these rights being infringed upon as we go through into modern history. And so as Christians, we're very keen to be aware of these issues. To that end, shortly after the Constitution was ratified, there was a Bill of Rights added. The first 10 amendments are oftentimes called the Bill of Rights. And those guarantee the rights to fair trial, to free speech, to religious, to carry a gun, etc. We'll be looking more carefully at those rights and how the Supreme Court works to uphold those through a few activities in class. Also, the 14th and 15th and 16th Amendments were allowing those people freed slaves and other individuals the rights to life, liberty, and property, and due process of the law. The due process clause in the 14th Amendment includes that the Supreme Court, the government has to give you a fair and honest trial. The 9th Amendment also covers rights that you may not have heard of yet, that are not explicitly set out in the Constitution. What comes to mind is things like the internet, different privacy rights on the internet and so forth, things that weren't invented back during the time of the Constitution. The 9th Amendment says that some of these rights aren't even invented yet and that those also should be protected by the Supreme Court. As I mentioned earlier, the freedom of religion, the two that you should be familiar with are the Establishment Clause, which denies the government from establishing a state religion or giving any benefit to one religion over another. Now, oftentimes as Christians, we don't like this because we would prefer that the government gives preferential treatment to Christianity. And that sounds good because we are Christian. However, we have to be careful that what we wish for, because what if the government, if it is allowed to establish or to give favorable benefits to one religion over another, who's to say what religion that might be? So if it's our religion, then we're okay with it, but if not, then we don't want the government involved in religion. So therefore we have what's called an Establishment Clause, separating effectively church and state. Secondly, we have the Free Exercise Clause. And as mentioned earlier, this clause gives us the right to exercise any religion. Now, there are limitations to the free exercise. Some religions that require illegal activity or multiple wives or drug abuse or murder, these types of religious exercises are not free. So there are limits in our society to the freedom of religion. And there could come a day that our own exercise could be limited. We don't know that for sure yet, but at some time it will. The The Supreme Court has, of course, heard many cases having to do with religion. Some that you see described here on this slide had to do with public schools, which are a branch of the government. We don't agree with public schools, obviously. That's why your parents use a parental-run Christian school, because they feel that God has called parents to educate their children and to gather together and form good Christian schools. The government is not responsible to teach and educate the children. So we don't participate in this, but many people use the government-run schools. And because they're government-run, they are supposed to have establishment clause. They should not give anything to prefer one religion over another. That's why so many cases, if some lady puts up a nativity scene or some other emblem of Christianity or mentions God, they can a lawsuit could be filed. And a prayer, of course, has been debated in public schools, things of this nature. Usually we have to say, does it pass what's called the Lemon Test? That's a famous case where the government can aid schools as long as it doesn't have religious connections. Others, such as seasonal displays and prayers before Congress. There are limits, as I mentioned earlier. Sometimes religious movements will bring that to court, a case to court where they feel that their rights are being impinged, their free exercise, if the government has stopped them from a certain religious practice, like the Mormons or the Amish or other sects or groups have brought cases. Freedom of speech is also protected, symbolic speech as well as verbal and written speech. Now again, it's not without limit. You can't print false and damaging things about people or vicious lies, so you could be sued for libel or slander. Also, there are obscenity laws in many municipalities where you can't use obscene language. So there are limits to the freedom of speech as well. Another limitation is seditious speech. That is, trying to overthrow the government or encouraging people to rebel against the government. There's various laws against that as well, which limits your right of free speech. Obscenity is another one that's difficult to enforce because somebody has to decide what's obscene, and that does change from time to time based on cultural norms. And here's a brief description that the judges use in an attempt to decide what's obscene or not. Again, who decides? Well, ultimately, the courts have to decide if that communication is obscene and can be banned or not, or does it fall under freedom of speech. The media also oftentimes is embroiled in controversy with freedom of speech and confidentiality. For these purposes, the motion picture industry has been declared not an art, but a business. Therefore, the government can more closely regulate businesses than arts, because art, if you call it art, then you're free to use more questionable material if you classify it as art. Also, confidentiality, the media has not been granted the same level of confidentiality as, say, a patient to a doctor or lawyer to a client. The Constitution does guarantee your right to assemble as well. Bring your views as long as it's legally conducted on and not on private property. So please again read chapter 19 to review all of these different constitutional rights and how the courts have upheld them and tried cases on them. And again, we'll be doing some activities in class to try to bring these home.